All right, good afternoon, committee. Representative Wheeler, I like you to be my audio guinea pig. Can you hear us out there in the internet land?
Mr. Chairman, is there compensation for that, please?
I think you can submit your claim to the State Finance Council and they'll answer your question.
Don't worry, I'll take care of that. I hear you just fine. Thank you.
Great, thanks very much, John. Committee will go ahead and call the meeting to order. Begin our meeting today with requests for bill introductions. Are there any committee members who would like to offer any bill introductions? I see none in the room. I see no hands raised. Anyone else wishing to offer bill introductions today? Doesn't appear so. So we will move on with our business of the day. I'm curious, committee, are there any committee members who are participating via video conferencing that are not present in the Capitol building today so that we can determine whether or not you will be participating in the vote according to evidently rules that we have? Representative Keither, you are absent from the building, is that correct?
Yes, sir. I didn't see anything on the agenda that says we were going to be working bills today. Nope, but there it is. Yeah, sorry, my mistake. I'm sorry.
Not a problem. You're certainly welcome to voice your opinion from afar. We just won't be counting your vote today. How's that?
I'm sorry about that. I totally missed that. Otherwise, I would have been in the building. Sorry.
Not a problem. Not a problem for us. Anyone else? I can't see your pictures. I can just see your hands if you're... Okay. Looks as though everybody else is indicating they are present in the building, and we will then proceed with discussion and final action on House Bill 2081. We'll call upon the reviser to refresh our recollection concerning the content of this bill. Natalie?
Thank you, Mr. Chairman. House Bill 2081 modifies how certain prior convictions are counted for special sentencing rules and sentences when you're on supervision for when you commit a new crime while you're on supervision for felony release from custody. So the first change there in 216606, that's the change that currently those, when you commit a new crime, those sentences have to be run consecutively. This would allow them to be served concurrently or consecutively, however the court directs. And then section 2 there in the drug grid, we're changing the special sentencing rules in E and F. Right now they say has a prior conviction. We're changing that to the sentence for a second or subsequent conviction, and then there will be a technical amendment hopefully offered to fix that drafting mistake where that one needs to say one or more prior convictions instead of two. And I can take any questions.
Thank you. Committee, questions for the reviser? Representative Owens?
Thank you, Mr. Chairman. Natalie, so is this, the first part of this, is this whether they're on pretrial release or post-trial release, or does it matter?
Mr. Chairman, I was going to direct you to the exact language there on page 1. It starts in line 33. So while on release for a felony, I believe that's pre-trial release. Let me double check that though, just to make sure. Yeah, so that's going to be released prior to trial. The article in the Criminal Procedure Code related to that, so it'll be on pre-trial release.
Thank you for that clarification.
Representative Heiberger.
Thank you. And now the second change is really just a clarification, correct? There was some question about whether the counts in a current charge counted toward the second hire. Is that accurate?
Yes, and I believe the testimony from the McPherson County District Attorney's Office clarifies that that there was some confusion about whether they were both in the same case, whether they actually count as priors there, because it says on the second or subsequent conviction. So we're just changing that to be very clear that we mean like two prior convictions from previous cases.
Committee, other questions? Looking for hands raised electronically. I think we've covered all the hands in the room. I see none. We will move on to discussion and possible amendments being offered. I would begin with offering an amendment to House Bill 2081, which is the technical amendment that would correct on page 6, line 35, where it currently has the word two or more prior felony convictions, and correct that to being one or more prior felony convictions, consistent with the testimony that we received during the hearing. I believe the amendment is now being shown on your screen, at least that pertinent part, and is likely, are you going to email these out too? Is that the idea, or are we just doing it on the screen? So it should be arriving in your email. This, I don't believe, probably comes as much of a surprise to anyone given the testimony that we had, but it is simply changing the word two to the word one on page 6 with respect to prior felony convictions. So we'll give you a couple minutes to get that. We have the motion. Is there a second on the motion? Representative Heiberger seconds, and discussion. Committee, any person wish to be recognized to discuss the motion to amend? I see no one in the committee room, and at this point, no hands raised. I see the email should have just arrived in your inbox, hopefully, if you wish to review this other than on the screen as we had it. Does anyone desire more time to review and consider the amendment that has been offered? I see no indication of a desire of additional time. I would just say this is a technical amendment to correct the language consistent with the testimony that the committee received, and I would move my amendment. Those in favor, please raise your hand on the amendment. Okay, electronic hands, please be raised if you are supporting the amendment. Okay. Looks like we're there. All right, I believe everyone who is eligible to vote on this amendment has voted on the amendment, and that the amendment passes without objection. We'll proceed then to further discuss House Bill 2081 as amended. Do any other members have any amendments to offer or discussion on the bill as amended? I don't see anybody raising their hand in the room. Any virtual hands wish to go up to discuss the bill as amended? Representative Owens, go ahead.
Thank you, Mr. Chairman. As I've read through this, I was actually trying to kind of review my notes from last year on where I voted on this, because again, this is a rehash of last year. And as I recall, last year this one died in committee. I don't recall any specific reason that I did or didn't write down even how I voted or why I voted on that. As I read through this, it seems like to me that it gives judicial discretion when somebody's on release. I have my hesitations that when we have somebody on felony bond release, that we, in essence, are allowing for leniency, but at the same time, I believe in our judicial discretion as well, because it allows for consecutive and concurrent. So I just find myself contemplating these things, and I just thought maybe that would stimulate a little conversation or share my thoughts.
Appreciate that. Thank you, Representative Owens. Representative Smith?
Well, I guess tailgate on what Representative stated there, I'm also, if there's anything that has me in a quandary on this, it's the idea of adding concurrent to consecutive. I believe in our system also. I believe in the discretion of the judges, but I think there are also limitations that we put in that have a purpose. So I'm not saying that at this point, and the reason why I haven't brought an amendment at this point is because I'm not concrete on this, but it is the one that gives me the most contention. So if anyone has ideas about that and wish to share, I'd be open to it. Thank you.
Committee, other comments? I guess I would offer just a couple of observations. One is the way that the law is now, we know that it's not consistently being applied by the courts. From the testimony that we received from the Sentencing Commission, that a substantial number of, if you will, departures from the statutory scheme are actually occurring in the real world on a rather regular basis. Judicial discretion and individual circumstance, and the individual circumstance, I think, weighs into this. I can also think of a scenario where someone who is charged with a felony, released on bond, commits a new felony that this might apply to, but ultimately they are not convicted of the original felony for which they were released on bond, which would seem to enhance a penalty for someone who in fact was innocent perhaps of the first felony charge. And then lastly, this becomes more readily something that prosecutors can use in coordination with plea negotiations in terms of whether or not it would be a consecutive or concurrent sentence that might be imposed under the statutory scheme. Right now, it would seem that they would be precluded from doing so, although I suspect if we looked carefully at the cases where the law is not exactly being followed consistently, it is likely in part because prosecutors, in fact, are making those kinds of deals and the courts are agreeing to go along with them, even though statutory scheme might suggest it's not provided for. So I think on balance, there's probably at least the opportunity to square things with the real world practice in a way that kind of makes sense and doesn't push people to ignoring the law, which I always think is kind of not a good thing to have happen. And there's not much for a defendant to complain about if they ended up getting a concurrent sentence as opposed to a consecutive sentence. So appeals on agreement are not going to happen. Just some thoughts. Representative Smith, you have something further?
Yeah, well, in response to what you're saying, I think that you touch on two things that actually are the things that give me pause, and one of them is that we are going to put in another, whether it's concurrent or consecutive, which opens that subjectivity even more, in my opinion. And then number two, something you brought up, and I thought of that scenario as well, but should a person be found not guilty on the first one, whether it's concurrent or consecutive will not even enter the picture. So those two sentences won't confound each other anyway. But yeah, that's exactly what gave me pause. Thanks.
Committee, any other discussion on the bill as amended? Representative Owens?
Thank you, Mr. Chairman. Reviewing Scott's testimony, Director Schultz's testimony, it appears that the application of such is that about 62% of the time they did receive consecutive sentences, as the law said. But there was a departure to concurrent about 10% of the time based on 2019 figures. So if we have a law on the books that says that they have to be consecutive, yet it's still being applied concurrently at the discretion of the court, is the court just operating outside the legal bounds of their authority in doing that? Or are they doing some kind of specific departure process that already exists that I don't know about? Or what is happening there?
So something of a rhetorical question, but Natalie, if you have any sense of what the answer might be to that 10% question, feel free to field it. If not, it's understood.
Yeah, I think Scott might be a better. I know he doesn't appear to be on. I don't know if he's in the room. I kind of doubt it, but he might be better equipped to answer that.
Committee, any other comments or discussion? Okay, I see none. With respect to House Bill 2081 as amended, what's the desire of the committee? Representative Heiberger.
Mr. Chair, I move that the committee recommend House Bill 2081 favorably for passage as amended.
Is there a second? Second, Representative Smith. Any further discussion? Seeing none, those in favor of recommending House Bill 2081 favorably for passage as amended, please indicate by raising your hand. You're all good here. Okay. And very well. It appears the motion passes. Motion passes. It will be reported out favorably as amended. Thank you, committee. We'll move on to the second.
Mr. Chairman, Mr. Chairman,
yes.
I'd like to have my vote recorded, please.
Yes, sir. And your vote being recorded as a
affirmative vote.
Thank you. And Representative Heiberger, your affirmative vote as well. Representative Owens will be recorded as an affirmative vote. Sorry for not pointing that out, Representative Carmichael. It slipped my mind.
That's about the most important thing I'm going to do today in this committee.
Mr. Chairman, I would also note that.
Mind slip, or I'm sorry, Natalie, go ahead.
Scott must be dutifully listening in as always, because he did just send me an email to indicate that deals can be made between like the prosecutors and the defendants in the cases, and that the court is just willing to follow those in those circumstances.
Right. No harm, no foul. Nobody to appeal the order because everybody agreed to it, right? Okay. We will move on then and move on to House Bill 2083. Natalie, would you be so kind as to refresh our recollection concerning House Bill 2083?
Sure, Mr. Chairman. House Bill 2083 would make changes to the membership of the Kansas Sentencing Commission. So the 4 legislative members right now, they're appointed by the Senate President, Senate Minority Leader, the Speaker of the House, and the Minority Leader in the House. This would just add to that those 4 members would have to also be members of the House Standing Committee on Corrections and Juvenile Justice on the House side, and the Senate members would have to be members of the Judiciary Committee. And I can take any questions.
Any questions for the reviser? See none in the room. Representative Carmichael, your hand remains raised. Is that your vote, or you wish to ask a question of the reviser? It disappeared, so it's not a reviser question. Okay. Committee, House Bill 2083 is open for discussion and amendment. I am going to offer an amendment, just a very brief discussion on the amendment. I believe, I certainly sensed and agree that deference to our leadership officers and their selections and appointments during a term of biennium, even though this is not term limited by the language of the statute. This would be kind of changing horses, if you will, in the middle of the stream. In deference to that, while I agree that there is certainly a logical argument that can be made that the Senate Judiciary Committee and the House Corrections and Criminal Justice Committee are likely the members that have developed the legislative expertise around the subject matter compared to other members of the legislature at large, that in order to avoid that potential conflict with midstream changing, I am going to offer an amendment that would do one thing very simply, and that would delay the effective date of this bill until January the 9th of 2023, which would be the first day of the next biennium of the House. Frankly, the Senate may say, well, good for you, and we want to go to 2025 with their side, fine, or they may not want to do anything at all, but I think this at least resolves the questions that were in folks' minds in this committee about the implications this bill would have at this point in time. So I would offer that amendment. It is on the screen for people to look at online. It is line 22 and inserts that the act shall take effect and be enforced from and after January the 9th of 2023 and its publication in the statute book. So there's a two-step process there, but it would be effectively delayed. Is there a second on the motion to amend? Representative Owens seconds. Any discussion on the motion to amend? Or questions on the amendment? Representative Heiberger.
Chair, the amendment is to say January 9th, 2023, and its publication in the statute book? Would that not delay the starting the effective date until July 1st, 2023?
Natalie, technical question on publication. I guess I assumed when I saw this that publication would actually occur July 1 of 2021 with the effective piece of it being delayed until January of 2023. Is that correct?
Mr. Chairman, the way the effective date operates, you have to have that publication requirement. And so what typically happens when something becomes effective January 9th, it's a decision that's made by our editor, but typically that will be published in the statute books the previous July. And then it will just take legal effect starting on January 9th. And there will probably be a reviser's note in there indicating that the change that you see there isn't actually legally effective until January 9th.
Thank you, Natalie. Questions on the amendment, discussion on the amendment? I see no hands raised. I would then close and move the amendment. Those in favor of the amendment, please raise your hand. Okay. It appears we have a significant majority. Representative Heiberger voting in the affirmative. You want amendment votes too, right? Representative Heiberger voting in the affirmative. Representative Carmichael voting in the affirmative. Representative Owens voting in the affirmative on the amendment. The amendment passes. We're back on the bill. As amended, House Bill 2083. Is there any further discussion or offer of amendment? I see none. What's the will of the committee with respect to House Bill 2083 as amended? Representative Heiberger.
Mr. Chair, because I'm on the commission, I'd rather defer to Representative Patton on this one.
Representative Patton.
Thank you, Mr. Chair. I move that we recommend House Bill, what's the number?
2083.
2083 favorably for passage as amended.
Is there a second to the eloquent motion of Representative Patton? Seconded by Representative Day. Any further discussion on the motion or second? I see none. Those in favor, please indicate by raising your hand. Very well, it appears a majority having voted in the affirmative. Those indicating no vote, please indicate by raising your hand. Any noes? Majority having voted in the affirmative, the bill will be passed favorably with recommendation of the committee as amended. Committee, I believe that concludes our work for today. Tomorrow you have a
Mr.
day
Chairman,
off.
could I have my affirmative vote recorded, please?
Yes, Representative Carmichael's affirmative vote will be recorded. Representative Heiberger's affirmative vote will be recorded. Representative Owens' affirmative vote will be recorded. Any other members wishing their vote to be recorded? I don't see any. We're done with that. Now we are done with business. Thank you again, Representative Carmichael, for not allowing me to let that slip by. Tomorrow is a day off. I want you to know it's not because there isn't work to do. It's a matter of the work having arrived a little too late from assignment to the committee to be able to give people adequate notice to prepare to have hearings. You should expect next week we'll have a pretty full week. Additionally, there's more bills in the bill mill, so we'll have plenty to do going forward. I appreciate your attendance today. Enjoy your time off tomorrow and have a good evening. We are adjourned.